Hello everyone, and welcome to the very first CLRNN webinar. September marks the anniversary, the first anniversary of the Commercial Law Research Network Nigeria, a network that was established to promote research and knowledge exchange on matters relating to the development and reform of commercial law in emerging economies, using Nigeria as our focal point. At the heart of the CLRNN network is the desire for a collaborative consultation amongst several stakeholder groups who research, practice, and adjudicate, also regulate the spaces in consideration. And as you can see, our panel cuts across board. It is fitting to hold this webinar on the cusp of the celebration of Nigeria's 60th anniversary as an independent nation, because of the pertinence of our history, our colonial history, to the understanding of some of the legal choices that we make in Nigeria, including CAMA 2020, which we are considering today. Professor Akintola, whose name many Nigerians would recognize, described CAMA as a landmark company legislation in Nigeria because it was the very first indigenous company law in Nigeria. And it was born of the need to create a comprehensive body of legal principles and rules that are suitable to the Nigerian situation. Now, prior to CAMA, Nigeria had regulated its corporate space by indigenizing British company law. Our very first indigenized British company law was the Companies Ordinance of 1912, which was simply the transplantation of the Companies Consolidation Act 1908 into the Nigerian space. The last indigenized English Companies Act in Nigeria was the British Companies Act of 1948, which was introduced into Nigeria through the Companies Decree of 1968. Now, incidentally, at the time that the 1968 decree was being promulgated, the British Companies Act of 1948 had been amended by the British Companies Act of 1967, but no attention had been paid to that in Nigeria. So CAMA 1990 was therefore a unique experience for Nigeria. In March 1987, the then Attorney General of Federation and Minister of Justice directed the Nigerian Law Reform Commission, which had been established in 1979, to provide laws that were better suited to the peculiarities of a rapidly developing Nigerian corporate sector. The result was a compromise, a law that structurally aligned itself with the British style for the sake of clarity and continuity, but conceptually was novel in that it introduced a Nigerian interpretation of some of the key concepts. And for today, I will deal with the Nigerian receivership. The Nigerian receiver and manager is quite different from the creature that is created by the English jurisprudence. And I invite participants to pay particular attention to section 390 of the CAMA 1990, which created a receivership that distinguished itself from that which was practiced in the UK. Now, the receiver and manager in Nigeria, with power over the whole of the assets of the company, or substantially the whole of the assets of the company, was different from his counterpart, the administrative receiver in England and Wales. Because while the counterpart in England and Wales owed responsibilities only and solely to the appointer, which was the charge holder, the Nigerian receiver and manager was expected to pay particular attention to the interests of the appointer, that is the charge holder, in many cases the bank, but was not to pay exclusive attention to that interest. That receiver and manager was also supposed to take into consideration other interests in the company, including those of the employees as well as those of the owners of the company. Sadly, that practice was never normalized in Nigeria. And for me, we missed a key and crucial opportunity to contribute to the jurisprudence that on receivership that can be learned from across the world. Now, that type of receiver manager was conceived of by Professor Gawa, and very many of our listeners from the British and other Commonwealth regions would be very conversant with the work of Professor Gawa. At the time, he was the Dean of the Faculty of Law at the University of Lagos. And what he created was a hybrid between the administrator that is well known today in England and Wales, and which we are now bringing into Nigeria, and the receiver manager. The reason why he created this hybrid creature was because they had seen the changes that had taken place in 1986 of England and Wales, and the challenges that the administrative receivership style portended for that system. And they had noted that they would like a different approach to Nigeria, to have someone who is considerate of other interests in the company at the time when the company is going through a difficult time. So for me, that marked the introduction of a rescue spirit into the Nigerian insolvency space, which sadly, again, I must mention, did not take hold. Today, we celebrate the reform of our landmark CAMA 1990, which I'm very proud of after 30 years. And in this webinar, we examine the insolvency ambit of that law. It is very interesting to note that the insolvency ambit of CAMA 2020 appears to have, reintroduced the indigenization practices pre-CAMA era. It transplants the insolvency procedures of 2002, 2003, England and Wales into Nigeria as at 2020. And like in 1968, it's important to understand and recognize that these same procedures have been modified by an amendment act in England in 2020. That said, we must note that we cannot simply call it perhaps an indigenization. We could call it a transplantation with some adaptations, because we find, for example, that one of the novel changes that has been introduced by CAMA 2020 is a moratorium that goes along with the schemes of arrangement. But I'm sure Dr. Sanford has much to say about that in his talk. And we also see that the reformers of CAMA have been speaking very much about the changes that they have introduced, which suggests to us that they are interested in the participatory approach to law reform that the Nigerian Law Reform Commission espoused in 1979. With that, I would like to introduce our panel for today. So, Mr. Seni Adio, SAN, led some of the activities that delivered the reforms of CAMA that we see in CAMA 2020. And he was the erstwhile chairman of the Nigerian Bar Association Business Law Section, and he will be telling us about this journey. Right after him, we have Mr. Okorie Kalu, who is the Secretary General of the Business Recovery and Insolvency Practitioners Association of Nigeria, BRIPAN. And he will be telling us about the participation of BRIPAN in the reform procedure, as well as some of the key issues that BRIPAN has noticed, particularly in relation to regulation of practitioners. We also have with us Hon.Justice Dr. Nnamdi Dimgba, who is a judge of the Federal High Court of Nigeria, as well as a visiting senior researcher at the University of Reading. And he will be giving us insights from the judiciary. We then have Dr. Kayode Akintola, who is a lecturer at the University of Lancaster, and he will be telling us about the expenses of corporate rescue. Bringing up the rear would be Dr. Sanford, who is a senior counsel at ACAS-Law, and he will be talking to us about the philosophy underlying the changes that we see in CAMA today. So without much ado, I would like to say first, welcome to our students. from the University of Reading and across Nigeria and the world who are listening. Welcome to all of our panelists. Welcome to all of our listeners from wherever you've tuned in. And I hope you are as excited as I am to listen to and to learn from the esteemed panel that we have pulled together today. I would like to pass on the floor now to Mr. Seni Adio, who is the Senior Managing Partner at Copley Partners. And I will put on the chat box a little more about Mr. Adio's esteemed practice. Mr. Adio.
Thank you very much, Professor Adebola, for the introduction. I'd like to say welcome to our distinguished audience, our e-audience, since we're doing this virtually. I would also like to especially recognize Honorable Justice Dimgba, who is very erudite in so many spheres. He's also an expert in competition law, also known as antitrust law. So we're very privileged to have Dr. Justice Dimgba on the panel. My task today is, I think it's, at least in terms of what I will be presenting, is fairly straightforward. But I'm told that I need to watch out for very probing questions during the Q&A, and that's fine. I'll be ready for those. My task is to give a helicopter view of the process that got us to the passing of the bill that became CAMA 2020. And so that's what I'm going to do. I'm going to be speaking exponentially, and that's fairly easy to do because none of this is contrived. So it's really what happened. And Professor Adebola has given a very good background in terms of the history of company law in Nigeria. So I will start from the so-called 1990 CAMA. And as we all have discussed at various fora, for about 30 years, we had the same law. Meanwhile, company law is very dynamic, the space is very dynamic, the players are very dynamic. So by the time CAMA 2020 was enacted, a lot needed to have been done decades ago. But thankfully, we're where we are now. I'll start by saying that, in terms of giving credit, I think credit needs to go certainly to the executive for ultimately Mr. President, President Buhari assenting to the bill. A lot of credit also needs to go to the National Assembly, and in particular, the 8th and 9th Assembly. We were very fortunate that we had a convergence of the National Assembly, legislature being in sync with the executive, and that's how this all came about ultimately. In terms of the process, it's been a number of years. There have been many attempts to repeal and reenact a new company law, if you will. But ultimately, we began to have some traction around 2016, if I recall correctly. If I were to use the SBL, the Nigerian Bar Association Section of Business Law, as a reference, I think I was probably, my last term as the secretary at the time. And what happened is that there was discussion about trying to get the private sector and the public sector to collaborate and work collaboratively, as opposed to the ad hoc manner in which we had worked in the past. And for some reason, I was designated to lead that effort on behalf of the SBL. And frankly, I've said this before, I wasn't really convinced about whether it would be successful or not, but I'm certainly an optimist, and we took the charge. And essentially, it began with the Nigerian Bar Association Section of Business Law working hand in glove with the Nigerian Economic Summit Group, the NESG, and also the National Assembly. Now, the National Assembly being at that time the 8th Assembly. The 8th Assembly, at that time on its own, had been working with the UK DFID, a multilateral agency, through one of its programs called Enable 2. So ultimately, the four of us started working together: SBL, NESG, National Assembly, UK DFID. And after about a year and a half of working together, we decided that this was working very well, that we ought to formalize our structure. And that resulted in what became NASBA, which is the Nigerian National Assembly Business Environment Roundtable. And through that process, a certain number of legislations were passed, one of them being the Secured Assets Immutable Transactions Act and the Collateral Registry Act. But the big one, there are a few big ones, CAMA being one of them. Then the Investment and Securities Act is another one that we're hoping will be signed by Mr. President in short order. But coming back to CAMA, it was a bit of a long, drawn-out process, but ultimately the interests were aligned, and we essentially keyed into the mindset of the executive based on two fundamental pillars. One of them being to ease doing business in Nigeria and generally making the Nigerian economy more competitive. Put another way, it also included trying to remove bottlenecks in terms of doing business in Nigeria. So that was how that came about. And so we're working hand in glove also with the Office of the President Enabled Business Environment Council, PEBEC, which was situated in the Office of the Vice President. And, at some point, the SBL set up a committee of lawyers to help drill down and work on the actual wordsmithing of the bill, which ultimately became CAMA 2020. And at this juncture, I really ought to give credit to the SBL, but in particular, Ozofu Ogemudia, who was the one that we designated to just basically champion that effort, and she did a wonderful job. Now, the bill, the act has been passed, as Professor Adebola has mentioned. There's certain, and we all know some of the innovative provisions in the act, including essentially making it easier for micro, medium, small enterprises to do business, removing various bottlenecks, including, for example, small businesses no longer have to have audited financials on an annual basis. Small business folks can incorporate a limited liability company with one shareholder and one director. You're not required to have a secretary. So various things have been removed. Coming back to the reason why we're here today in terms of insolvency, some of the innovations include the business rescue provisions. A lot of that was drilled down into by, Kalu, Okorie, I'm sure Mr. Akintola and Dr. Mba, Dr. Akintola and Dr. Mba will be talking about that. Now, I will just put this out there and wait till the questions come. One thing I will say is that for the most part, the bill, the act has been very, very well received. I mean, amongst other things, Nigeria has gone up exponentially in terms of ranking by the World Bank on ease of doing business. I think cumulatively, we've gone up about almost 40 points from a very low of 169 out of 190, and I think about 141 or thereabout now. The goal is to be in the top 70 ultimately. But one thing I'd like to just mention, before I conclude in 2 minutes, is that, the process, because I've heard from certain quarters that perhaps there wasn't sufficient consultations, or there weren't sufficient consultations. But the thing is that there were public hearings. There are public hearings, as a matter of fact, and I took some time yesterday. I didn't have enough time to get to being able to give you all the dates for the various public hearings, but I did find one through an invitation that certainly we received. I think it was in February of 2018, late February of 2018. 2018, there was a notice that was put out by the National Assembly inviting interested stakeholders for a public hearing. So yes, so it was on February. It was in May 2018. It was in May, yeah, 2018. So there were public hearings that were held, and so people had the opportunity to submit written memoranda, also to appear in person and give their comments. It's possible that after perhaps the initial public hearings and when views were collated and the bill was amended, perhaps towards the end, there wasn't as much opportunity for people to now look at the revised bill, so to speak, before it was ultimately assented to by Mr. President. That's a possibility, but I'm not a member of the National Assembly, so I can't give you all the specifics as to the dates and what happened. But certainly there were public hearings, and so I guess what we ought to do now is, to the extent there are stakeholders that have strong views as to how the act can be improved, what you need to do is, collate them, for example, to Professor Adebola. You can send them to Nigerian Bar Association Section of Business Law. You can send them to National Assembly. And at some point, when the act is being looked at to be revised and improved, in quotes, those recommendations will be taken on board and considered, and if they are found to be meritorious, I'm sure they would be incorporated to make the act even better than it already is. So, like I said, mine is to give a helicopter view as to how far we've come. But like I said, in terms of the rubber hitting the road, that started in 2016. So that's 4 years of really, really solid hard work, culminating in the assent on, I think it was on August 7th, 2020. In terms of the work the SBL did, I don't know how many law firms, but quite a number of law firms, providing personnel pro bono in terms of man hours, also the traveling back and forth to Abuja, everything was done gratis. So I'd like to commend and salute my colleagues in the SBL for that effort. Like I said, I will be brief, I'll be succinct. That's my helicopter view. Now, I'll be open to questions during the Q&A. Those of you that may want to come after, those of us that were involved in the bringing about of this act, to the extent you have issues, I'll be happy to respond as best as I can. So with that, I'll stop for now. Thank you very much.
Thank you very much. Thank you very much, Mr. Adio, and we do appreciate the efforts that has been put into the enactment of the reforms. It's been 30 years, and we know that there have been several attempts to reform this law, and we also know that successive Nigerian governments have been interested in upgrading or facilitating the ease of doing business in Nigeria and providing adequate laws to support the commercial sphere in Nigeria. But we will take you up on this offer to grill you during the Q&A session. And with that, I invite Mr. Okorie Kalu, who also has insights, having been a first-hand participant in the process of the reform of the insolvency aspects of the CAMA 2020, to give us some insights into that experience, as well as some points on regulatory and other issues that arise. Mr. Okorie Kalu is a partner at Punukka Solicitors and Attorneys, and he's the General Secretary of the Business Recovery and Insolvency Practitioners Association of Nigeria. And I will put more about Mr. Kalu's impressive resume in the chat section. Okorie.
Thank you, Prof. Good afternoon. Well, I had a little slide to present, but it seems that I don't have the opportunity to, I'm restricted for now, but I'll speak to the issues very quickly. Taking it from where my erstwhile president has stopped. I will be speaking about the journey and the process and what was available before the CAMA 2020 and where we are on that journey with the new CAMA 2020. Now, essentially, like has been said as a background, by 2017, early 2017, the World Bank Ease of Doing Business Global Report of 2016 was published, and Nigeria was ranked 169th out of 190 countries in terms of ease of doing business. And so the Nigerian executive decided to aggressively address that issue. And that led to the PEBEC and EBS initiative that would have driven the agenda of reform of our business climate to ensure that we have a better ranking. The vice president was the chairman of the Presidential Enabling Business Environment Council, and the Minister of Trade was the vice chairman, and Dr. Jumoke Oduwole, the senior special assistant, was the driver of the PEBEC and EBS.
Okay.
Yes?
If I could stop you, halt you there. You mentioned that you wanted to share your slides. Yes, you may share your slides if you just shared your screen.
Okay. I mean, okay. All right. So there was a flurry of activities by 2017, 60-day action plan, executive orders that were given, like Mr. Adio, senior advocate, had mentioned, two important laws in relation to information in relation to credit profile of debtors and in relation to securities in movable assets were passed in 2017. That immediately impacted on the ranking of Nigeria, which rose up by 2 points. It became 167th by the time that came in. And then the private sector was now also engaged, and the NBA-SBL came on board with a joint steering committee that was set up to work with PEBEC to work on a enabling business climate and make recommendations. But initially, the project was an omnibus law on Nigerian business climate project. And the model was taken from some of the work that the World Bank has done in the past in other emerging countries, where essentially you had different investment laws and business laws that were repealed through an omnibus law that will now, try to cater for different business indicators and ensure that we have a law that creates an enabling environment for business. So the World Bank report and the World Bank, business indicators, you had 14 business indicators. There was a working group for each of those business indicators, and working group 11 was on resolving insolvency, and as both wearing two caps, that of BRIPAN General Secretary and that of the NBA-SBL Banking and Finance Committee Vice President, I was tasked with the job of leading a team of professionals to make recommendation on improving the insolvency framework of Nigeria. And it was quite a tasking job because we were given 8 weeks to come up with all this work, interaction, stakeholders discussing those issues, and then coming up with recommendations, not just legislative reform, but even institutional reform recommendations to regulators. And so that was how intensive it was. And I must say that under the leadership of the VP and his team at that time, there was a great sense of urgency. There were executive orders that were put up that led immediately to digitization of various ministries, departments, and agencies of the government to ensure that bureaucratic bottlenecks and all that was cut down and improve on the environment. So I will go to the old framework under the CAMA for insolvency. Incidentally, our job was limited to corporate insolvency and not personal insolvency. And we were asked to take a look at CAMA, which was, of course, the general framework for insolvency in Nigeria, being, as Prof has mentioned, embedded in the Companies Act of 1948 that we took and transplanted in our Nigerian framework, but with the adjustments that she so rightly mentioned, particularly the issue of receivership that she mentioned, that I think I will quickly comment on that. It is true that a more interesting framework for an administrative form of receivership was created by the CAMA framework. But unfortunately, the culture, which takes you to the issues, item 2 that I'm discussing, the culture was a liquidation culture. And there was virtually no business rescue culture. The framework was ineffective, uncertain in terms of the protection and enforcement of creditors' rights. There was no versatility in terms of restructuring tools. We did have, under the old CAMA, the scheme of arrangement, which is a neutral tool for restructuring. It could be used in insolvency and solvency, as the case may be, but it was really not also of common acceptance, so to speak, in terms of the practice in Nigeria. There was a lot of lack of proactiveness or cooperation and culture when it came to the relationship between creditors and debtors. So essentially, we did not have any recognition even of informal corporate workout, and there were weak implementation in terms of the institutional and regulatory framework. There were some form of progress that were made by special regimes like the AMCONS Act, which created a regime of administrative receivership, which was a bit more interesting and was actually in the line of the philosophy, the Gawa's philosophy that Professor Bolanle so eloquently mentioned. And that progress was made in 2015, even before this initiative by the government on the general insolvency framework came on board. We were able to identify a lot of issues that related to the challenges that we were having. We did not have any cross-border insolvency rules. We did not have any proper test of insolvency. We did not have any statutory recognition of informal corporate workout, which we felt a new law should achieve so that you entrench a better rescue culture in and out of court. We needed a more robust provision to identify the rights and liability of directors in the event of insolvency. We needed a regulation on insolvency practitioners. The issues that we had identified about information asymmetry when it came to insolvency administration was partly addressed by the two laws that has already been mentioned, the Collateral Registries Act and the CMAA Act. And we also felt that there should be some adjustment in terms of ranking in priorities and exceptions to that, such as the concept of critical suppliers or essential services when you are having, a formal restructuring procedure, so that gives a better chance for the debtor to be able to continue as a going concern. We also thought that the CAMA should be improved, or the omnibus law should improve the rules in relation to wrongful trading and reckless trading, because the old law only had fraudulent trading under the old law, which, because of the nature of it, the criminal nature of it, restricted, a lot in terms of flexibility. And so these were all some of the background, and a lot of recommendations were also made in relation to the issue of developing capacity for the judiciary, training of the judicial officers in relation to what business restructuring entailed, and when business restructuring should be the priority, even training of judicial officers like the office of the Deputy Chief Registrar, which acts as an official receiver in Nigeria. And we also made recommendation for regulatory changes. In Nigeria, since the abolition of the universal banking system, there are restrictions for banks, to make investments. And of course, restructuring sometimes involves a situation whereby you have arrangement like debt to equity swap and so on and so forth. So we were making recommendations to have a situation whereby you will have the regulators, such as CBN, having, a framework that will allow, in insolvency situation, the banks to accept to a certain limit taking equity in some of the debtor companies, and so on and so forth. Now, a lot has been mentioned in terms of the legislative process and all that. I can't speak much to that because I think my job might just stop at the point where we made our recommendation, and then PEBEC published a report of those recommendations with 14 business indicators, and then it was taken up with the National Assembly. And I think that Mr. Adio has also given a proper update on that. But the idea was that I think that we left the omnibus law project, and the next thing was that CAMA reform was on hand. And so they decided to onboard some of these issues in the CAMA legislation. At BRIPAN, we had, prior to that, and BRIPAN had been quite involved in terms of legislative advocacy and reform since 2010. We had initially come up with the UK Insolvency Act, even though even at that point, those were not very solid considerations, because by the time we were working in 2017, there was a clear paradigm shift for us in terms of practitioners, that UK has its own problem, and that Nigeria had a culture that required that we should develop more of the debtor regime, because Nigerians are entrepreneur at heart. And the US approach to insolvency, debtor imposition, had a lot of success because of that recognition of that entrepreneurship spirit. And so we tried to make some of those recommendations in terms of how to balance those issues and creditors' rights and regime, and also strengthen the enforcement of those creditors' rights in those recommendations that we made. Some of them have found their way in the new CAMA, and that should be something that we should commend. The issues about regulations of insolvency practitioner, including certification through other professional bodies. At PEBEC level, we recommended BRIPAN, ICANN, and the NBA, which are essentially the professions that one way or the other involved in insolvency practice. We also made recommendations to improve the corporate insolvency regime, and there was clearly an improvement of the rescue framework with the administration and CVA schemes that were accepted and brought in. We also had a situation whereby the winding up threshold was increased. There were other recommendations that were made that did not find their way. But all in all, we can say that, I mean, from where we were, it was quite a substantial shift from where we were, particularly in terms of the restructuring culture that was now being brought in into the new CAMA. Even in terms of the ranking of priorities, in terms of exceptions in relation to essential services or critical supply, the new CAMA has a few of those provisions, including a better framework for preference rules and transaction undervalue, wrongful trading, and so on and so forth. Are we in the promised land? No. There are major gaps. There's no cross-border insolvency framework available under the new law. There is still, from what we understand, a new effort to revamp the proposed omnibus law, which may be a framework for us to do further work, as the learned Sikh has mentioned. My only concern is on this issue of stakeholders' participation, because I know that personally I have tried to get more information on these issues on 2 occasions since last month, since the new CAMA came up, and it appears that there is some form of, will I call it, the information is not disseminated very well to stakeholders. So I don't know the experience of us, and we'll see how it goes. Thank you very much. I can't hear you.
Bolanle, you are muted, please. Please unmute yourself.
Thank you very much for your presentation, Okorie. What's a webinar if you don't hear, unmute yourself. Thank you very much for that presentation. It was really detailed, and there have been questions coming up for you and Mr. Adio, and we will pick up on some of the issues that you have discussed. We turn now to the view from the judiciary. As is well known in England and Wales, the system that we have here has a caretaker, and that is the judge. So it is the judiciary that helps to hold the ring between all the various stakeholders in the insolvency and rescue system. And so for today, we turn now to Hon.Justice Dr. Nnamdi Dimgba, who is our judge from the Federal High Court of Nigeria, as well as a visiting senior researcher at the University of Reading. And he will be giving us the view from the judiciary. Justice Dimgba.
Oh, thank you very much, Dr. Adebola, at least for the opportunity to come and be part of this discussion. Can you hear me? Yes. Yes. I just thought that my presence there is in the interest of what I consider to be fair representation, because I feel a little bit insufficient sitting, in a table full of experts. I thought I was invited to be on the table. Let there be that there's a representation from the bench. Okay, that's what I think. But what I want to say is just to affirm what has been said earlier, that the CAMA 2020 is perhaps the most significant business-related legislation in Nigeria in the last 3 decades. From a judicial point of view, I know that even though cases like a number of cases such as rental airlines had always said that you shouldn't use debt recovery action as a substitute for winding up proceedings. But this hasn't actually deterred lawyers and litigants in Nigeria, because you see consistently people have always resorted to the debt winding up petitions, the liquidation of companies as a mechanism to recover debts which have been owed to them. And I think partly this is actually an aberration or an anomaly, that which CAMA itself seems to be a bit responsible for. Because if you look at CAMA simply says that if a company was unable to, CAMA 1990, if a company was unable to pay its debts, and you make a demand and is not honored in a 3-week period, and then you can then file for winding up. And the amount involved was, I think, 2,000 naira, which with hindsight was very little. So what it then meant was that once people, these conditions are satisfied, which I think was quite easy to satisfy, people felt very free to file for winding up of companies. Then that then promoted the issue of liquidation culture and not a business rescue culture. And the reason for it, I think, is because we didn't really have any intermediate options in the old CAMA then. You had the scheme of arrangement, as Okorie mentioned, that was that really employed? No. So recourse was then had to come up. But the fact of the matter is that even if you look at that CAMA 1990, a company may be unable to pay its debts because that company has a cash flow insolvency issues. But the fundamentals of the business are great. The assets are great. It has very great receivables. But if it has short-term liquidity issues, not able to pay its debt. But if you look at CAMA, by the letter of it, that seemed to be satisfied then. So people can then file for winding up. So happily for now, we now have these innovations which have been introduced by CAMA 2020. And it's given a number of roles, judges, to perform the judiciary. If you look at, for example, if I can quickly run through them, by the way, let me also mention that if you look at the new CAMA 2020, the provisions on insolvent liquidation winding up have been pretty much retained the way they are anyway, apart from the improvements in the monetary threshold for cash flow insolvency, which now is no longer 2,000 naira, but 200,000. And then for registered companies, 100,000 instead of 100 naira. But I think if you look at it, very, very dispassionately, that will appear also very easy to satisfy, in my own view. Okay, one knows what the value of naira is today, so 200,000 is not that great of a threshold to begin with. And then if you take that one away, the courts have powers to impose a number of fines for infractions, penalties, monetary penalties for infractions in CAMA, even though some of them has to be set by regulations made by the CAC. And I think maybe the reason for that is to enable the CAC to be able to adapt and adjust to the value of the naira and the conditions in the marketplace to decide what is fair. But what we thought was it would have been nice if the lawmaker had set sort of a minimum amount or criteria that the CAC should look at before it then imposes or sets these fines. Okay. But the other role is when it comes to company voluntary arrangements, that has been introduced now, and the courts have responsibilities to discharge. They have to make a submission of the proposals and the minister's opinions to the court to look at and to sanction. Then the returns also have to be made to the court as well. There's also a provision for a challenge of the company voluntary arrangements to the court, which the court would consider. And some of the factors we looked at is if it is unfairly prejudicial to the person bringing it, or if there's a material irregularity. These are the things the court will look at then to decide whether to set aside those proposals or to approve them. We then go to like administration as well. A number of it's been done, as Mr. Kalu spoke about, and the courts have a great role to play, like in appointment of administrator by the court. And then the court has to look at if all those conditions are there, like if it is satisfied that the company is or is likely to become insolvent, or it is likely to achieve the purpose of the administration, and all of that. But what I would just like to say, thereby promoting a business rescue as opposed to liquidation culture, but what I would just like to say very quickly is that the provisions in CAMA 2020, which I've mentioned now, there are novel provisions in Nigeria, but they're not unprecedented because the presidents have been drawn from jurisdictions where they've been practiced for quite a while. And I think Dr. Adebola mentioned the UK, starting from the Insolvency Act of 1986 to the Enterprise Act of 2020. We've had this, the administration arrangements in England, and a body of case law have developed from there, a number of principles. So even though it is new here, it is not new in other jurisdictions. So for us who are courts, we're going to look at precedents and authorities, from the UK and other jurisdictions where this has been practiced to guide us in where we're going to resolve some of the issues that will come before us here. And if you look at, for example, if you look at the English jurisdictions, a number of principles have been there for us. Go, for example, to the issue of whether the court should make an administration order. One of the things to consider is that there has to be, you don't have an admin order just for the fun of it. You have it because, well, unless if there is a reasonable prospect that the company is going to be rescued or revived, or so that's a going concern. Because you need to also bear in mind that even administration, the expenses are incurred by that, and these expenses which are borne by the company that's already facing difficulties. So if you then if there's no reasonable chance of the company being rescued, you go through that process, spend money, and then you ultimately end up in liquidation and also run double expenses as well, more like a double jeopardy arrangements. The law is that if there is no reasonable prospect or arguable case for the rescue of the company, there's no point going into administration. The court will not make that order. The court will just say, you better move on and have liquidation once and for all, okay? Then the other consideration is that, and that's, for example, for prepackaged administrations, most times administrations are being driven by the major creditors of the company and the company itself. So even the scheme, the proposal you're putting forward have been agreed already by the this I mentioned, the company directors and the major creditors. It may well be that at the end of the day, it doesn't actually take full into account or accommodate sufficiently the interest of unsecured creditors. So the courts would have to look at those proposals. If the court is not satisfied that that unsecured creditors have been fairly treated or they've been disadvantaged, the court would not approve of any proposals put forward by the administrator. These are some of the principles that have come out from these jurisdictions, and which I think is going to guide Nigerian courts in trying to apply and to enforce these provisions. That's number one. Then the other thing I would like to say is that I did say it's not new in other jurisdictions, but it is very new in Nigeria. So for us courts, for us judges, we're going to need, training, capacity development. That's one thing that, one must not ignore. And I'm quite happy that when Mr. Kalu was making his presentation, he did say that that's very much on the board, on the table. But because particularly, how many key insolvency cases do we have in Nigeria? How many people are really that specialists in it? You don't have that critical number of core insolvency cases that you will say, okay, you now have judges, enough judges that have developed specialization knowledge about it. We all do need training, we all do need assistance. So that should not be overemphasized. The third and perhaps final point I will make is that I have looked at these provisions, CAMA 2020. One thing we must note is that even with the CAMA 1990, sometimes you have a situation where you have very nice provisions, great, but then the justice of the case do not converge of the case, do not converge with the provisions. Provisions are great, but they don't meet the justice, they diverge in a way. So what do? We courts have to maintain vigilance to ensure that litigants and lawyers do not use the provisions to actually abuse the system. And I say that because I remember I'd give an example even with the old CAMA, which I noted is also retained now, this thing about winding up voluntary liquidation and all of that. If you look at the old CAMA, which is also here now, it says that the company can also apply for voluntary winding up. You pass a special resolution, and then you have a declaration of solvency. Once you have that, you can have a voluntary liquidation. But there have been situations, where you had offshore directors of companies, a company that's owing so much to Nigerian creditors. So directors escaped from jurisdiction and they applied for voluntary winding up, and they had special resolution and the declaration of solvency. Nobody really audits declaration of solvency. It's not audited anyway. So even though it's a declaration which are made, the effect of, they say, okay, if it turns out that in 12 months or so, the debts are not paid, it converts into creditors. But the fact of the matter is that somebody who wants to escape from justice from Nigeria can file those declarations and escape. It happened in Nnamdi, West Africa Limited, which I remember, I think Mr. Kalu was aware of that, where that happened. And then they went, I remember that Dimgba had to insist that we have to apply for the thing to be converted from a voluntary, members voluntary winding up to creditors voluntary winding up. And the court granted the order. The court only granted the order because the court was minded to grant the voluntary winding up order, but compulsory winding up on application of the shareholders. The reason why the court couldn't go ahead was because on the day of the hearing, they sent, the directors who had escaped from Nigeria sent a letter to the court that they were not going to subject themselves to the court's jurisdiction because they had gotten wind of the application filed by Chief Dimgba to arrest the winding up proceedings from the shareholders to the creditors. So situations like that would always occur every now and then. It is for us courts to be quite vigilant and ensure that people who approach us using these provisions do not in fact use it to cause to abuse and also to cheat people and to so that's what I think about it. So finally, I think it's very great innovations which have had the courts are there to play our own part in making sure that the philosophy and the reasons behind it are actualized. Thank you.
Thank you very much, Dr. Dimgba, Honorable Justice Dimgba. That was very insightful. And of course, we will be back to you on these questions of specialization and training of the judges and your interpretation of some of the case law that come before you. But you talked about some of the practices that you observe in the court, as well as you mentioned the expenses of rescue, particularly if it then happens that there is a failure of rescue. And I'm glad to say that we have Dr. Kayode Akintola on hand, who is a lecturer at the University of Lancaster, who will talk to us about the expenses of corporate rescue. And I will, as I've done with others, put more about Dr. Akintola in the chat. Dr. Akintola.
Thank you so much, Bola, and hi to everyone joining us on this webinar. I'm going to be talking about the cost of rescue. And what I mean by that is how do we fund the expenses associated with a rescue procedure. In terms of expenses, there are two issues worth noting. The first is the cost of the procedure itself. So the issues that the administrator or office holder, whatever title the office holder may have, will get involved in. How do you pay for that cost? How do you pay for the cost of valuers, the fees of lawyers that will be engaged by the office holder? That's one aspect of the expenses. The other aspect, of course, is the fees or the charges of the office holder itself. So that's something worth noting. So the cost of rescue is an important issue. And I suppose there are quite a number of strategies that have been involved, that have been used over the years to deal with insolvency expenses. And I'm particularly interested in this short discussion in 4 strategies, which I'll come to in a second. But a useful starting point, ladies and gentlemen, is to understand, as Honorable Justice Dimgba has just mentioned, that insolvency rescue is not a costless exercise. In fact, it is not only commercially complex, it is also an expensive process. Now, one may wonder, why is it expensive? What is involved in a rescue regime? Let's take administration as the poster child of the rescue provisions in the new CAMA. Well, an administrator, for example, will be involved in a number of commercial works. For example, if it's a trading administration, they have to continue the business, continue paying some employees if they adopt those employment contracts. They probably have to engage in valuation of assets at some point when they decide to sell those assets. And even in a non-trading administration itself, they will be involved in issues like gathering, marshalling, realization of assets, trying to engage a valuer to get a proper value for those assets, ultimately selling, trying to swell the assets as well. So can you improve the value port for the general body of creditors? Do you need to engage in certain legal proceedings in order to do that? How do you fund all of this process or processes is quite an important issue. Now, if we take that point to mind, that rescue is quite commercially complex and also expensive, we also need to consider whether it's appropriate to rescue in insolvency, because insolvency in itself typically is not value enhancing. It's usually value diminishing, if you will. Now, what does that mean? Quite a number of stakeholders are agnostic about the idea of a company being in insolvency anyways. Once you hear the I word, you start to have a massive mistrust of the particular corporate entity. Save in fundamentally debtor-friendly jurisdictions like the United States, when you're dealing with what I consider to be debtor, typically or traditionally debtor-hostile jurisdictions, in which much of the common law world is, you've got to be very mindful that the value of the assets you're dealing with might not necessarily be enhanced because the stakeholders do not trust the process. So rescue is all well and good, and permit me, or forgive me rather, for using a very crass and hip metaphor here. Well, I believe what rescue may make your insolvency regime more sexy, it probably will make it particularly attractive. Its attraction will largely depend on where the value lies. You know, what is the financial outcome in that particular process? Now, Justice Dimgba mentioned that it's important to avoid a double jeopardy. Now, for members of the audience who are appreciative of sound bites, here's another one. I think office holders are likely to try to avoid an insolvency, okay? By the sheer definition of insolvency in itself, they have very limited assets. So why would you want to go into a process under the guise of rescue and you find out that you don't have enough money to conduct the rescue and ultimately not be unable to meet your own fees? So this is quite an important issue. How do we deal with the costs associated with an insolvency rescue procedure? Now, when Okorie was talking, he mentioned the innovation around, or the novelty of dealing with essential supplies and essential contracts. Now, that's quite an important point, but it still raises the question of costs and how you pay for those costs. Now, so I'm going to talk about 4 strategies very quickly. I'm going to talk about the compulsory funding regime, talk about voluntary funding regime. We're going to talk about pre-packs very briefly, and also what we term the light touch administration. Now, bear in mind, of course, this important question: do we need to rescue in insolvency? And I'm very glad to hear that the judiciary are going to be hopefully paying close attention to this, because ultimately what we found in this jurisdiction, i.e. the UK, is that it's not unusual that many administrations are in fact disguised liquidations. Now, what that means is that you are perhaps wasting more money to the detriment of the general body of creditors, in particular the unsecured creditor, who are residual claimants amongst the body of creditors. Now, back to the strategies for dealing with insolvency expenses or the cost of rescue. The first is the compulsory funding regime. In many jurisdictions, there will be a compulsory provision within the insolvency aspect of the legislation that provides for the expenses of the office holder to be paid out of assets subject to a particular type of security or a particular security interest. In the United Kingdom, that's typically the floating charge. The simple reason being that the floating charge typically covers the entirety of the undertaking. And of course, the office holder comes in and is in charge and manages that undertaking and ought to be paid in priority to the claims of the holder of such assets. Now, in the UK, if for those who are interested, you can consult paragraph 99 of Schedule B1 to the Insolvency Act 1986. But I'm particularly interested in Section 537 of New CAMA, which provides that those expenses will be paid out of the payment, out of the value pot of secured assets. Now, it provides that that will be assets covered by security, to which Section 510 applies. Section 510 applies, and Section 510 in itself is quite a blanket description of secured interests. It does not distinguish, if you will, between fixed charges and floating charges. Now, of course, that might be an error in a sense, but we obviously await the gazetted version of this law. But I think that's something worth noting. What assets do you want to use to fund insolvency expenses? Do you want to capture the floating charge, or do you want to capture other types of security? Now, if you try to capture fixed charge assets, as the text of the version of the law that I'm privy to seems to suggest, I think that's quite an important point worth being mindful of. Well, there are 2 issues here. The first is that, well, general property law might stand against that, in the sense that if it's a fixed charge asset, by definition, the chargeor has committed not to use those charge assets without the consent of the fixed charge holder. And if we accept that the administrator in this context, even albeit an agent of the court, is an officer, or albeit an officer of the court is an agent of the company, the administrator effectively steps into the shoes of the company's officers. So by reference to general property law, that's probably a misnomer to use fixed charge assets in that way to compulsorily fund insolvency expenses. The other aspect is that you also run the risk of having a statutory contradiction. What do I mean by that? 510, I believe, provides that you ought to be mindful of any administration proposal that tries to jeopardize the priority of the particular secured creditor or a preferential creditor. Now, if you are paying insolvency expenses in priority to fixed charge assets, that obviously jeopardizes their priority position, because insolvency expenses typically auto rank after the fixed charge holder has received their net proceeds from the realization of those assets. So the compulsory funding regime is one worth noting. Most jurisdictions, as I've said, will top slice that the expenses of assets subject or covered by floating charge. Well, the second aspect is the voluntary funding regime, and that's something we ought to keep an eye on. Chances are, due to the various provisions in the CAMA that affect this floating charge in particular, particularly the right of the floating charge to appoint an administrative receiver, the application of the insolvency expenses regime under 5372 floating charges, the ability of the administrator to also use floating charge assets to fund the procedure under section 507. There might be a move away from floating charges, and you might have a shift to other types of security. So what do you do when you don't have a particular pot of money to utilize, or a particular range of assets to utilize to fund the regime? Well, one of the things you could do is to have a dialogue with typically the fixed charge holder. Now, you might ask yourself, well, why would the fixed charge holder consent to voluntarily funding the expenses of the administrator, where they could actually run along and under section 476 rather decide to appoint an administrative receiver? That's obviously open to them. But there's a sense in doing this, because on the one hand, it's important to have a collective regime. On the other hand, the enforcement process in an insolvency is not necessarily easy. And if they can get the cooperation of the administrators, then the enforcement of their assets is probably taken out of their hands, but the realization is in a sense secured. Of course, they would have the benefit of an agreed and fixed cost in terms of the office holder's expenses. And hopefully, if rescue is probable, then they have the opportunity to look forward to a rescued entity, be it the original corporate entity or a new business that they can continue to relate with. So that voluntary funding process requires quite an integration or interaction in terms of the role of the office holder and the role of particularly institutional creditors like banks, who would have all-encompassing debentures, which would no doubt include a fixed charge. The third regime is the prepackaged administration. Now, a number of you will be alive to the concept of a prepack, but for the uninitiated, the prepack administration simply means that you negotiate the terms of the sale of a company's business under a proposal that suggests that you would try to achieve a better realization for the general body of creditors as a whole that would otherwise be available in winding up. And once that is done outside of an administration procedure, once you've negotiated the sale, you come into an administration procedure and immediately execute the sale. Now, you might say, well, that's not explicitly provided for in the legislation. Well, neither is it in other jurisdictions where this works. And that's something that the courts would need to be alive to. It requires a lot of stakeholder management. It requires a sensible and heavily regulated body of insolvency practitioners who would not be engaged in value stripping to the benefit of secured creditors and to the detriment of the general body of creditors. So you need quite a concerted effort here in terms of training, in terms of understanding. And I think the judiciary has got quite a significant role to play, because you've got to understand the proposed value of the company's business and whether that's been properly valued in terms of the realization after the whole valuation exercise. So that's something we ought to consider. But there's a question stands alongside the collectivity, the idea of collectivity, and obviously the role of the floating charge holder. Because for you to sell an entire business, you're probably going to be dealing with the holder of a floating charge that has that all-encompassing debenture. But one of the benefits here is that because you are doing a sale outside of this insolvency process, Hopefully that removes that value depreciation that is typically associated with insolvency. And again, you can minimize costs. It's perhaps beneficial to the floating charge holder because the returns and realization are accelerated at a minimized cost. But of course, you can also use that process to agree costs and fees on the part of the office holder. So that's one strategy, but again, that's something that is heavily scrutinized even in the United Kingdom. There are proposals to make legislations for that, or to legislate around pre-pack. So this is an area that I think requires further scrutiny. The last strategy that I'm concerned with this afternoon is the light touch administration. And that's quite, that's a practitioner novelty, if you will. And that was largely in response to some of these issues of costs. Now, it is possible to do this within the legislation. In the UK, we will do this under paragraph 60 of Schedule B1 to the Insolvency Act 1986. Under CAMA, I believe this is possible under the wide powers of the administrator, sections 496, 498, and the fact that they can continue to permit the directors to act under section 501. And those are aspects that you can consider as an office holder in order to minimize your cost. The light touch administration simply allows the office holder, enables the office holder to permit the directors to continue to exercise certain managerial functions. Now, what that means is that the administrator is obviously there, perhaps in the quasi-supervisory capacity, but certain day-to-day functions can still be exercised by the directors. Now, it means that the administrator is not obviously running certain costs as they would. And the caveat around this, and we had obviously some practice direction, well, a draft protocol rather, from chambers here in the United Kingdom. You've got to be very clear that the reason why you're doing this is to rescue the company as a going concern. So that the first paragraph under the purposes of administration. Furthermore, you've got to ensure that the liability of the office holder is considered. Can the office holder basically abdicate their duties in this way? It's not really an abdication of duty when you consider that the office holder is allowed to take whatever decision that is expedient for the management of the business and of course to orchestrate the rescue. So one of the things they can do in that regard, with a view to keeping costs down, is to permit the directors to continue to exercise certain powers of management. That's been trialed in a case here recently with Debenhams. Unfortunately, that case of the company all ended up in liquidation, but it is still worth considering. I think, again, we need to consider the protocols around that. We need to consider the legalities around that in terms of the office holder liability, and also in terms of directors' liability for continuing to act, even though, of course, they're acting in that in a sense as agents of the company and pro tanto the administrator who has been appointed over the company. So that's worth noting. So those four strategies I'll cover some of my discussions or my thoughts around how we can deal with the cost of rescue. And I'm happy to take questions in this regard. Thank you very much for listening.
Thank you very much, Kayode, and that's really important. I mean, the issues that you raise bring to mind, lots of questions about the direction that we should be taking in Nigeria. I don't want to get ahead of myself and start the question and answer session because we still have one more person to talk to us today, and that would be Dr. Sanford Mba. Sanford is a senior counsel at ACAS-Law, and he's also written extensively on the Nigerian insolvency law and the philosophy that we should be taking. So Sanford, the floor is yours.
Thanks very much, Bola. Thanks to all the panelists. Thanks to our listeners. So, Bolanle, I'm going to be taking something narrower than you had envisaged. Of course, I'll talk about essentially the building blocks of rescue as we understand it, but I'm narrowing down a lot more to the moratorium provision in this whole rescue. The rescue provisions of CAMA 2020. If you don't mind, I would like to share my slides. Essentially, I won't be running through all of it. Sorry, I won't be able to run through all of them, but I would just, touch on what I consider to be the very basics in the course of the time allotted to me. So, may I? One second. Sorry. Okay. Can you see my slides, please?
Not at the moment.
Okay.
Just while Sanford is sorting that out, I will just say that I see some hands that have been raised. If you could type up the comments or the questions that you have either in the chat stream or in the Q&A section of the chat, we would be able to deal with them.
Okay. Files. I'm not quite sure I can find my slides here. Okay, here we go. I'm sure you can see the slides now.
Yes.
Fantastic, fantastic. Okay, so I will just so I'll be talking essentially. I'll be critically examining the moratorium provisions in CAMA 2020. But of course, that would come from a more general analysis or opinion about how our rescue culture, what our rescue culture is, and what the key elements of this culture should be, talking from an international perspective or best practices perspective. And then I would drill down to our provisions on moratorium, specifically relating to the administration procedure that's been recently introduced, and then including as well as that of the schemes of arrangement which we have just now adopted. Right. So in terms of content, I would give a general overview of CAMA. Much has been said about that already. So I will just limit myself to the key points that I would want to emphasize. And then I would look at moratorium as a key or essential component of the rescue regime, any rescue regime, as a matter of fact. And then I would go on to look at how CAMA 2020 has treated the moratorium provisions in the Act. And then I will just talk broadly about recommendations or lessons that we should have learned from things I'll be discussing now. So on I go into the presentation. We all know, and I think Justice Dimgba mentioned this, that CAMA is one of the most significant business legislations in Nigeria. In fact, we would say that CAMA, has for every time we mention business legislations in Nigeria, it has a pride of place. And it has essentially engendered, it has done a lot in terms of spurring our economy and things of the sort. So I think that CAMA is an important legislation. And it's also very important because it has played, of course, before we had the passage of the AMCON Act, the amended AMCON Act, it has played an essential role in ensuring that in resolving the insolvency of distressed businesses. Now, whether the outcome has been favorable or is it something that we are proud of, I will leave that question for another day. But well, like it or not, it has been the legislation that we've had in place for the purpose of resolving distress or insolvency of businesses. And no matter how badly you think of CAMA 1990, you would find that it still has served some purpose. I was going through some of my documents and I realized that even as at 2019, the arrangement and compromise was used by AG Leventis, for the purpose of their restructuring. Essentially, it was a restructuring that was done as a result of harsh economic conditions, right? And then that procedure may well have served some purpose for in helping them to emerge from, I don't know whether they've emerged from their financial distress, but again, it was a case of making lemonade out of lemons, you know. And so having set that tone and that background, we all know that the purpose of a restructuring regime is essentially to help the business, to give that businesses, and when I say borrower here, please understand that to mean companies in the context of CAMA, right? Essentially gives them the opportunity to restructure or achieve a turnaround and then provide creditors, right? A going concern value better than what they probably would have received if the company was, you know, liquidated, if you had an insolvent liquidation where the assets of the company were sold in piecemeal and then with less value coming to the stakeholders of the business, right? So I will just go on to talk about what I consider to be the key elements of debt restructuring and why a moratorium is key to that process, right? So generally speaking, and talking from multiple jurisdictions, right? 4 things at least have to be present. More like I would consider them to be the building blocks of restructuring, right? First of all, you need an enabling environment. You need to enable your borrower to use as much of its assets as is possible to facilitate the restructuring, right? In addition to that, you should be able to provide some kind of breathing spell for the borrower to be able to formulate what is considered a workable restructuring plan, right? And then in addition to that, you would also need to now, you know, formulate that plan, right, in agreement with your creditors or your critical stakeholders, as the case may be. And then you would have to ensure that the right management or supervision is in place to achieve desired restructuring. And now you know that for many years, people have been torn between whether you need to leave the debtor in possession or whether you want to have a fresh management coming in place. I remember one author who says that, you know, if you leave management in place, it's like leaving a drunkard in a beer parlor, you know, and things of the sort. But I think attitudes have changed over time, and you have an approach that essentially, apart from, you know, what you see now is an approach that even if the debtor is in possession, you get somebody else, a monitor, by whatever name, who supervises the process of that restructuring, of course, in addition to the role played by the courts, right? Why moratorium? Why do I think that moratorium is always very important when it comes to debt restructuring? Well, it is essential for the purpose of preserving the assets of the business and to support the restructuring that the company is undergoing, right? Sometimes you would find that depending on how expansive your moratorium is, it also frees up some kind of cash flow for the business in the process of restructuring, so that things that would have been tied down to servicing pre-restructuring matters would now be freed up, and then it can be used for the purpose of achieving, especially where the company is a trading company, right, to be able to achieve the restructuring. It also prevents the race to collect, and it affords borrowers the opportunity to focus on the restructuring of the business. Now, you would find that if, as a company, you announce to your borrower, to your creditors, whether your lenders or whether your vendors, you say to them that, look, we want to restructure, you would find that people would, I mean, there will be a race. Everybody wants to collect what they can get. So that's like, think about it as a pool. You do not want to model this pool up, right? And so with the moratorium in place, you're able to collect the assets, no matter how small it is. We all sit on the table, and then we decide how and in what manner the assets will be, you know, utilized for the purpose of successful restructuring. And then on that note, finally, I would say that it helps to safeguard the priority repayments that some restructuring regimes would have been placed in their laws. So for instance, the administration in the UK, you would find what could be considered as priorities in terms of restructuring, So who gets paid first, who follows, and on like that. But if you, without a moratorium in place, then you cannot ensure that this would happen. Now I would go on to talk about the moratorium in CAMA 2020. Now I will just say this before I go on, that I have this this funny feeling when I read this CAMA, especially in the light of its moratorium provisions. You know, it makes me sort of I have this emotional feel that comes with it, because I get so excited looking at the provision, and then when I think I'm about to get to that climax, I just realize that there's this sense of palpable disappointment. I apologize for that expression, but then there's this disappointment that comes. I'll give you an example of why I have said this. So essentially, Section 480 of CAMA 2020 provides for a moratorium, right? So essentially, you would need the consent of the administrator and the court before you enforce security over the distressed borrower's property. And when I say borrower, I essentially mean the company, right? You would also need their consent or the consent of the administrator and the court before you repossess, when landlords want to re-enter premises, and when the legal process, where legal process of proceedings are ongoing or are to be instituted. So this is the limit of what moratorium is provided for in CAMA. But you know, the whole idea of the moratorium is not just when the court gives that order. At the time when creditors learn that this company is troubled, right? It is possible to preempt the application for administration, right? So that means that if as a creditor, I know that somebody is going to, this company is not, the financials are not looking very good, I can seek an enforcement. If I even know that that the company is filing to apply for administration, I may well decide to seek enforcement or to you know, file a creditor winding up proceedings against the company. So what happens within that intermittent period between when the decision is made to file and when the order of the court is granted for the purpose of that to begin administration? Now you will find that CAMA makes an attempt, CAMA 2020 makes an attempt to provide for what happens in that situation. And this is typically called interim moratorium, right? And then what you find, and this is where the excitement comes, you see Section 481 saying, well, when an administration application has been made and the application has not been granted or dismissed, right? Or if it has been granted but is yet to take effect, right? You say, okay, what happens, right? It says when a copy of notice of intention to appoint an administrator is filed with the court until actual appointment takes effect, or 3 business days, and on like that. So you want to see, okay, what is the provision for what kind of moratorium do I get before the court grants me the order to appoint an administrator? And then subsection 4 says, and this is where you would expect that interim moratorium comes to play. But then section 475, so it says the provision of section 475 and 476 of this act shall apply without regard to any reference to the consent of the administrator. Now, what this tells you, it gives you an idea to say, look, okay, a moratorium comes into play here because the administrator, the consent of the administrator would not be required for the purpose of protecting or preserving these assets or the assets of the company. And then you go to section 475 and to 476, and what do you see there? It talks about the application for administration by a company liquidator. 476 talks about the effect of appointment of a receiver by a holder of fixed charge on the application for the appointment of an administrator. And you say to yourself, where is the interim protection for the distressed borrower, right? So essentially, I would say that section 481, as far as I can see, and of course, subject to better argument, section 481 sub 4 is an ineffective section. So it means that the company is still exposed, that prior to when the court gives its order for the appointment of an administrator, the company is left to the whims and caprices of its creditors. Okay, because of time, I'll quickly move on to section 717 of the scheme of arrangement and its provision relating to moratorium. So 717 is a section that talks about moratorium. So yes, a 6-month moratorium is provided for under section 717, but before the company begins to enjoy that moratorium, so to speak, from the moment, I'm sorry, can you still see me?
Yes, Sanford, we can.
On my screen?
Yes, we can.
Fantastic. We can see your screen, yeah.
Fantastic. Okay. Now, we have a 6-month moratorium in place with the schemes of arrangement. Now you realize that in the UK, especially, one of the complaints against the scheme of arrangement has always been that it did not provide for a moratorium. So when parties begin to negotiate, the company is still bound to fulfill all of its pre-distress obligations, right? And I think this CAMA 2020 went a step further, but I have my complaints about it. I'm sorry, I sound like a broken record, but again, the idea of all of this is to ensure that we have a workable regime, restructuring regime that serves the purpose for which it was enacted. So it lists a couple of documents that you would have to provide, but the moratorium already starts running. Okay, and here are my complaints regarding this particular section. Oh, I forgot to mention, I think Bolanle had mentioned this early on, that in 2020, the UK also passed amendments or reform to make brief amendment to its Insolvency Act, so the Insolvency and Governance Act, I believe, that now provides for a moratorium, a standalone moratorium, as a matter of fact. So that did not depend on which restructuring regime you're trying to implement. Now, what I see with our moratorium here is that it makes an assumption that the company would have made its plan ready before it approaches the court to seek a moratorium. I feel that there's an inverse here, because normally you go to you get the moratorium so that it gives you the breathing room or breathing spell so that you can now prepare this plan, working in concert with with the relevant stakeholders that you intend to involve in that process, right? But here what we see is that you get the moratorium, then you must have had the plan ready before, and I see the mischief that this is trying to prevent, so that you do not have a borrower who is not ready but wants to take advantage of the moratorium provided by the Act. But then it also creates another problem, like I've mentioned, right? So that means that during that process, while you're preparing the plan, a creditor can take any action whatsoever, you know, before you're done preparing your plan and on like that. And then the other question I have is, who supervises this moratorium? And I heard, just like the learned Justice had mentioned, that it is very possible to see abuses when it comes to issues like this. And I would think, again, since we copied the law since we transplanted majorly from the UK, I would think that we would have followed developments in the UK also, right? And then for the standalone moratorium that you have in the UK, you would find that a monitor is supposed to be appointed, and his job essentially is to ensure that the moratorium process is not abused by the borrower, right? And then another intriguing provision that I find is what I consider to be some kind of carte blanche that is given to secured creditors with regard to exempting them from the applicability of this moratorium. So if you see section 712, sorry, I just need to be sure I have that. Yes, if you see section 712 or 718. Anyways, essentially, one of the exceptions to the moratorium in the scheme of arrangement is that a secured creditor can be exempted if the company consents to
its exemption from the applicability of the moratorium. And I find that really interesting, and it gives me this feeling of regulatory capture, you know, but I'll keep that, well, I was going to keep that feeling to myself, but unfortunately I've had to feel it. Now, the question is this, and maybe not a question, but from practice experience, with this kind of provision, as counsel to the lender, I know what to do. So by the time I am, before the borrower draws down on any facility which I'm providing, I will simply create a condition precedent, which requires the company to consent to exempting me from any scheme, so from any moratorium with regard to any scheme of arrangements that it might bring up. So what happens when the company decides to engage in the scheme, start a scheme of arrangement? I will simply present that letter, and I would say, look, the company has already exempted me from this moratorium, right? So at the end of the day, what you realize is that, well, the purpose of that moratorium may well be defeated, you know, if you give secured creditors that kind of right or opportunity to be exempted, you know, from the applicability of the moratorium. Okay, so in terms of recommendations, simple. I think, and I know that the Leonard Silk had made some comments about the engagement. I think that we could make the engagement broader in terms of making legislations of this nature. This is a legislation that, and you know, for Nigeria, where it takes a lot, too many years. We're talking about CAMA 1990, which is about 30 years. For a company or business legislation of this nature, I would think that the broader the engagement, the better for us. And I think that we might have to rework some of the rescue provisions, because I think some of those problems pertain to the numbering, error in numbering of the sections. So I think it's something that we can rework. And then in the interim, I think that the judiciary can play an important role in filling the blanks that the law has created. I'll give you an example. In the UK, for many years, the scheme of this, you did not have moratorium for schemes. But there was one case, I think it's the Blue Crest case, where the court allowed, you know, prevented a party from enforcing its rights because there was the parties were in the process of or within a scheme of arrangement, right? So I think that the court has an incredible role that they can play as the gatekeepers, you know, and they can exercise quite a good amount of discretion when it comes to rescue-related matters. And then the question which I have is, are we looking to see another wave of reform? I know Mr. Adio had mentioned this early on, you know, we can write to the National Assembly and all of that. So maybe we'll see another wave of reform, the CAMA, and then we'll see where that takes us going forward. Bolanle, I'm sorry I had to take a bit more time, but please forgive me. And this is the end of my presentation.
Thank you very much, Sanford. If you could please stop sharing your screen now.
I will, thank you.
Thank you for taking us through your thoughts. And yes, the section you were referring to there was section 717, subsection 2, referring to the 30-day period that the secured creditor has to sort of get out of the moratorium.
I'm trying very hard to get out of your face with my.
I will stop it from here. Okay.
Thank you.
All right. So thank you. It was, I have learned a lot listening to all the panelists, and I'm going to whiz through. I think Mr. Adio might just have escaped this this grilling that he was promised because of the shortness of the time that we have left. However, I'm going to start with Dr. Olawanye's question, which you have partly answered, but again, this is something that I have mentioned before, and I did observe when I wrote at length on the Nigerian insolvency system and the Nigerian insolvency reform. At the time when CAMA 1990, by now you know I am incredibly proud of CAMA 1990. At the time when CAMA 1990 was enacted, there was a reform report that came with CAMA 1990, and it was an annotated report that explained the decisions that had been made, the philosophy of the law, and explained the points of departure of the law from the English system. But with CAMA 2020, we are given entirely brand new provisions without such a consultative report that is attached to it. Is there such, there must have been something that the various people brought together during the collaborative phase. Is there a report that we're expecting to come along with the CAMA 2020 when it is made available to us all? Mr. Adio.
I think I already gave an abridged response in writing to the very incisive question from Dr. Olawanyi, and now Prof, you also raised it. And my response was that the technical advisory committee that worked on this did submit a very detailed report to the President of the Senate. That was done in late January 2018. But certainly the report does contain the rationale behind the innovations that were made, and also the rationale supporting the changes to existing provisions and so on and so forth. That report ought to be a public document, and I think in my response I had indicated that I can see to that. I think it ought to be something that's readily available. And, you know, my overarching comment also would be that whereas it may not be as detailed in terms of, you use the word Prof, annotations. I mean, annotations very, very specific. That requires some kind of deliberative process in terms of annotating and cross-referencing. I'm not positive if that report contains annotations in the way you have described it. But certainly, you know, the folks that we had work on the report would have done that exercise, you know, as part of the work that they did. But those folks, you know, it wasn't done under the auspices of the National Reform Commission. You know, and there was certainly, you know, the pressure also of trying to make sure that this come to fruition, or that it came to fruition. And I think, frankly, you ought to be applauding us for the work that we have done. And with respect to the areas that perhaps can be improved upon, I have two things to say to that. One, I'm glad we have, you know, Hon.Justice Dr. Nnamdi Dimgba, because he's very erudite in a number of spheres besides insolvency, antitrust, like I said. So I don't think we should underestimate how resourceful our judges can be. And I've heard people use the adjective discretion. They're innovative, and they would apply the law in a way that is reasonable and logical. And finally, the Registrar General of the CAC, I know A.J. Abubakar is a very commercial individual, and CAC ultimately is going to be promulgating, implementing regulations. Yes, those are subsidiary instruments. They're not statutory, but I'm sure they'll be compelling and persuasive in court, where the CAC itself has promulgated regulations to address the very salient points that Dr. Akintola and Dr. Mba have made. And I think Kalu had also identified some areas. And so those can be at least, to a large extent, if not cured in total, but at least addressed. And then those people who still have questions or also want to test the CAC's position, when they get to court, I'm sure Dr. Justice Dimgba and his colleagues, our lordships, will do the right thing. And finally, we should not wait until another few years before we start putting this together. I strongly believe that, again, the leadership of the Assembly, of National Assembly, they remain very commercially oriented. For example, the Honorable Speaker of the House, who I know very well, is a very commercial individual. If we bring compelling recommendations to improve the statute, you will get the attention, and then if we join hands, I'm sure we'll make it happen. So that's my 2 cents on that. So bring it on.
Thank you very
Sorry,
much,
Bolanle,
sir.
can I just say something, please?
Yes.
I'm just responding
Yes.
to Dr. Lawi's question. So if we're unable to get this annotated version of the report, it is also possible that articles of people who had first-hand information of all of this could also be written. It would provide insight. What was work? I mean, how was the minds of those who drafted these things? How was it working how were their minds working at the time, right? If we do not have that annotation that we would love, then I guess the second best thing is to get articles out there, papers published. Let us see what happened, what transpired in the course of the process of.
Thank you very much, Sanford, and Mr. Adio. I told you were in for it today, but in the interest of time, I'm going to have to whiz through this very quickly. You know, we have so many questions on this omnibus provisions and the like. Mr. Okorie, Kalu, I'm coming to you next, and please, if you can keep the answers succinct, short, concise. There are 2 questions I have for you, and I'd like you to whiz through them quickly. One is, how is BRIPAN working together with the CAC to ensure the regulation of would-be insolvency practitioners, existing and would-be insolvency practitioners? 2 is this, with you talked about your involvement in the process of the reform, and you talked about the reports that you put forward. When you were looking at the provisions of England and Wales, did you focus mainly on the act that you saw, or did you also look into the case law? Because the root of the system in the UK is the case law in conjunction with the act, so that we find that in Nigeria with CAMA, there have been provisions that were brought in from the bare face of the act without taking into consideration the cases that are the root of this. Could you talk to us about how you made your recommendations and what you considered?
Thank you. Thank you once again, everyone. Let me start with the second question. I'm sorry to burst your bubble, but the first and foremost, UK, US, and South Africa were considered. We had a team of about 8 people working on the different, frameworks that you had, and trying to identify a frame that will be most suitable for Nigeria. And like I mentioned in the past, while at the point where we were still advocating at BRIPAN at the beginning from 2010, to answer your question, we had looked at the UK Insolvency Act. We had also had some insight into there are a lot of subsidiary legislations that go with the UK Insolvency Act, and of course case law also that is developed. And in fact, that was one of the militating factor against going again into advising now as a multidisciplinary team that was both from members of BRIPAN and members of NBA SBL, to not to advise actually for us to go for squarely and solely a UK approach, because we felt that we do not have the capacity, even at the level of some of the supporting bylaws that will follow, to do a comprehensive work. And so there's no sense in beginning to go that way. So our approach was therefore recommendations that were going towards identifying certain framework. And I'm sorry to burst your bubble, we did not draft the insolvency provision per se that you are having in the in the CAMA, in the new CAMA. It does take from the old BRIPAN Insolvency Act. There's no doubt about that. but that was not the work that, or the assignment that we had at the point where we were working as a steering committee with PEBEC. What was your second question again?
Well, I will let you skip that first question because I want to hear quickly from Dr. Akintola and Dr. Mba in the interest of time. Everyone, don't worry, you will get the presentations and you will get some statements written by the presenters today on our website because this conversation has to continue. Dr. Akintola and Dr. Mba, I'll start with Dr. Akintola. You seem to suggest that we don't need a rescue framework in Nigeria because it is expensive and it might just be better to have a facilitated liquidation of distressed entities. Dr. Mba, would you agree with such a position? That would be your last word each. So if you could just go quickly to your answers.
Right, okay. Now I'll start with that. So my suggestion is not to have rescue. Rescue is fantastic, and we've got a global trend towards rescue. So when we get to the point of having a considered cross-border insolvency provision within our framework, it's important to have a rescue regime. The point is we've got to consider the financial cost and how we deal with that financial cost. And that requires some more input from different stakeholders, notably the office holders, insolvency practitioners, and of course the judiciary. I think it's a shame that the stakeholders are skipping the jurisprudence in other jurisdictions. There's quite a wealth of jurisprudence that we can learn from, certainly in terms of UK case law, as you rightly identified, in the context of insolvency expenses and how you deal with them. And of course, there are other common sense strategies that the judiciary can take here. So that's my 2 cents on that.
Thank
Sanford?
you. Sanford. Unmute yourself, please.
Bolanle, you know my position on this. I believe that a robust rescue regime emplaced by statute and is not only necessary but essential. And I say this because part of what Kayode has talked about has to do with costs. And I can give you an example of lessons learned from a place like Kenya. So in Kenya, you have only very few insolvency practitioners. It's like a closed list, like a cult, right? And as a result, even the fees of the insolvency practitioners is unbelievable, right? We can drive down costs by other means, but we can also engender a rescue culture. Understanding, like Mr. Kalu had mentioned early on, the entrepreneurial spirit of Nigerians and the fact that we want to make efforts, we want to do business without the fear of liquidation being the outcome of our failures. So I think a rescue culture is something that we should, rescue regime is something that we should have in place.
Okay, and I'll be interested in continuing this conversation, but I want the last word also.
It's really unfortunate that we can't
that we can't tear this apart. Another occasion. I would like a word from Hon.Justice Dr. Dimgba to tell us about, again, you can see here that the judges really are going to be the one holding the ring here. How do you intend to ensure that our judges are well positioned to perform this function excellently? Last word.
What I would just say very quickly is that I've always believed that judges do need to consistently expand their knowledge frontier, especially in the areas of business. And if you need to adjudicate in business, you need to understand how business works. I remember yesterday, I did give a judgment on a design. And for me to do that effectively, I had to go on Monday to go and spend the day with the people at the patent and design office to understand the way patent work. So that way I felt satisfied to write and deliver the opinion yesterday. So I think when it comes to what I was speaking about, judges do need to understand how businesses work. And why do I say that? I look at how smart Nigerians are. I know people can actually use the administration thing as a means to an end. And what is the end? The end is just to get a moratorium that gives you a breathing space for 1 year, whereas you don't really believe they are going to turn the company around. So what can judges do? If they understand business, they will be able to scrutinize the materials provided by people coming to get an admin order. If they're making outlandish claims that are clearly not supportable, realistic, business-wise, you can say, no, I don't agree with this, and then deny that. So that's what I would say. Yeah, okay, thank you.
Thank you very much, Dr. Dimgba. And with that, I would have to close the session for today. I know that everyone is still raring to go and there's tons of questions. We will try our best to respond to all the questions that have been presented to us. Look out for the write-ups by the panelists that would go on CLRNN.net. And we promise to host another webinar where we carry on these incredibly interesting conversations, drawing together, stakeholders from across the Nigerian commercial sphere and bringing them together with researchers so that we can have these collaborative deliberations that Mr. Adio promised that had taken place during the reform of CAMA. And we all look forward to CAMA 2020 and all the debates that would ensue. Thank you, everyone. Thank you very much for joining us today. Thank you.
Thank you.
Thanks.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you. Bye.
Bye.